First witness is the Canadian Association of Chiefs of Police, Lawrence Rankin. I hope you can hear me.
I can.
Excellent. And out in Vancouver, so I hope that we haven't got you up too early in order to be able to bring testimony. And Mr. Paul Martin, Chief of the Durham Region Police Service. And I understand you're going to split your time between the two of you. So I'm assuming, Mr. Rankin, you're going first.
That's going to make the opening remarks.
On behalf of the CACP, I just want to thank you for the opportunity to be here today and speak to the committee. Lawrence and I have been looking forward to this, and Lawrence is going to start out basically talking a bit about the CACP, CTNS, Counterterrorism National Security Committee's mandate, and then get into set the context, and then we'll talk about a few things just to set the context from the CACP standpoint, and then we're open to any questions after that. So I'm going to turn it over to Lawrence, and he can start off with us. Thank you.
Okay, thank you.
Chiefs of Police, or the CACP, is to lead numerous efforts to promote coordination and collaboration amongst Canada's law enforcement community to address threats to national security. So as part of these efforts, the CACP has implemented structures to help manage incidents and share information in support of a mutual goal to protect the safety of Canadians. Now, the Counterterrorism National Security Committee, which is part of the CACP, has a mandate to harmonize the work of Canadian police agencies throughout the country in identifying, preventing, deterring, and responding to criminal activities related to terrorism and national security threats. There's 5 priorities or objectives of this committee. First, to promote collaboration and integration among law enforcement agencies with appropriate public and private security and intelligence partners. Second, to improve ability to operate in a cooperative and integrated manner with a view of addressing emerging trends with respect to counterterrorism and national security. Developing processes and facilitating strong communication at every level, so at the municipal, provincial, and territorial levels. Recommending legislative reforms and promoting education and training in matters of counterterrorism and national security. There's been a number of initiatives that the committee has worked on over the past year. I'm going to focus on 3 for today's presentation. The first is the Provincial and Territorial Counterterrorism Guide. Now, this guide is designed to support the efforts in developing counterterrorism strategies at the regional, provincial, and territorial level. There are 11 key activities within the guide. Really, they're focused on 4 key strategies. First, to prevent individuals from engaging in terrorism. Second, to detect the activities of individuals and organizations who may pose a terrorist threat. Third, to deny terrorists the means and opportunity to carry out their activities. And fourth, to respond proportionately, rapidly, and in an organized manner to terrorist activities and to mitigate their effects. The second initiative is the Provincial and Territorial Integrated Response Structures. So the co-chairs of the Counterterrorism and National Security Committee have met with provincial and territorial chiefs of police across the country in an effort to encourage and develop an integrated provincial and territorial approach to for each province and territory to investigate and respond to terrorist activities. And third is the subcommittee of the Counterterrorism National Security Network, the Countering Violent Extremism Subcommittee, developed in August of 2015. This subcommittee is focusing on building training material that's consistent, addresses previously identified research gaps, and has a built-in evaluation tool to determine the programs that we are rolling out to determine the efficacy of those programs. So those are the 3 key initiatives. Thank you.
Thank you, Mr. Chair. I'll continue on. Thanks, Lawrence, Mr. Chair, members of the committee. Building on what Lawrence spoke about as far as harmonizing and working together as police agencies, from the federal agencies to the municipal agencies and the provincial in between, 3 major concerns for the committee to consider from the policing standpoint. There are perhaps many, but certainly 3 just for your consideration, are the terrorism peace bonds, the intelligence to evidence conundrum, and then encryption. And I'll speak to them separately. The terrorism peace bonds, they manage some of the threat posed to Canadian citizens, but not all. It does help manage in some cases, but something to consider is that with the terrorism peace bond, some of the conditions that are imposed, one of them being, I could provide an example, being that perhaps an individual subject to the peace bond is not permitted to use computers or not allowed to access the internet for a number of different reasons, which I'm sure are obvious. But there is no mechanism in place right now for police officers of jurisdiction to go in and ensure that, in fact, the person is complying with those conditions. So something for consideration. With respect to the intelligence to evidence conundrum, we know how the intelligence lives in one space, and then the enforcement piece lives in another space. My understanding is talking to my colleagues, some more learned than I, that have been involved in this field for some time, have said that this discussion has been ongoing for more than 15 years as far as how do we improve the speed, flow, and direction of this information so that we can share it in a quicker fashion. You know, incidents such as the Aaron Driver incident were made it very obvious to the policing field how fast information moves and how fast it has to move in order to detect, deter, and ultimately deal with a threat nationally. So it's something to consider as how that's going to happen. The 9/11 Commission was very clear on the fact that information needs to be shared amongst the different agencies, and police agencies right now do share a lot of information, but something for the committee to consider as this bill proceeds. Now, with respect to encryption, we've heard a lot south of the border as far as going dark. We've heard all these different terms. But encryption, whether it be in the hardware itself or with the use of applications that are encrypted end-to-end, this poses a very difficult issue for policing and how to monitor people that would carry on criminal activity, whether it's for terrorism or for organized crime. And we've seen a number of examples throughout in our jurisdiction and throughout Ontario and certainly across this country. I think that the important thing is we must be focused on the principles and not the technology. And where an individual or group is using any form of communication to support terrorism or other designated criminal activity, this may be intercepted by specified authorities with the proper and appropriate authority, judicial authority. Laws regulating access to communication data would be in principle the same as those currently in place for other forms of telecommunication intercepts. Companies ensuring data is available to access if required, warrants being issued by the appropriate authority, and then both time limits and regular scrutiny and review. So I throw that out to the committee to consider as we go forward and we talk about, or you talk about this bill. But those are really the top three concerns that seem to spread across generally throughout the policing community. Again, is the terrorism peace bond and the future of that, the intel to evidence conundrum, and then encryption. Thank you very much for your time.
Thank you, Chief Martin and Deputy Chief Rankin. Our first questioner is Mr. Spengelman. 7 minutes, please.
Mr. Chair, thank you very much, and Chief Martin and Deputy Chief Constable Rankin, thank you for being here. Thank you for your service and offering your expertise to the committee. I'd like to ask you in the beginning just to outline for the committee your sense of the current threat assessment, threat environment with respect to national safety and security. Your work is focused on terrorism, counterterrorism. Where does that rank with respect to other threats that the country is facing, including potentially cyber threats against our critical infrastructure?
Take this, Lawrence, or shall I?
I'll follow your lead.
Okay. Well, with respect to, it's always a consideration for us. Probably the biggest concern right now, as we discuss it at the committee level, is really the returning foreign fighters and the collapse of the caliphate overseas. So that poses a problem. Certainly we can look to our European counterparts and others in the Five Eyes community to say, you know, what has happened there? What can we expect here? So it is always top of mind with us, but there is a number of different ways terrorism can occur. And you've talked about the cyber attacks. We have the physical attacks by what we've seen overseas and even here for that matter, including Edmonton, where people have been radicalized to violence. So it is always a concern for us.
Okay.
And if I could just add,
please.
Now, recognizing that national security investigations are a federal responsibility as a municipal agency, we often are far more likely to engage or encounter the issue at first point of contact. And what we are finding is that the issues that we're dealing with that could have a nexus to counterterrorism or national security are often incorporating the subjects that we're looking at, cyber-enabled components of that crime. And just to add, I mean, these are issues that dovetail with encryption and that also have connections to radicalization that we are trying to mitigate at a municipal level, but working in collaboration with the RCMP and in particular the INSETs that we have members seconded to.
Thank you very much for that. So if it's fair to say that terrorism and extremism remains a prominent threat, is it also fair to say, you spoke about the imploding caliphate and returning fighters, but is it also fair to say that recruitment, either by right-wing extremist groups or by international terrorist groups like Al-Shabaab and the remainders of ISIS, remain a threat? In other words, fresh recruitment of Canadian youth who are particularly vulnerable to radicalization, to recruitment, and to becoming incorporated in these organizations.
I would agree with that statement. The fact that individuals that are interested and motivated to recruit people and to incite people to violence and to take action, they are using, of course, the cyber world, and they have used it quite effectively. So that is probably next to the returning foreign fighters is probably one of the biggest concerns that we have as a committee, and we do try to address that issue as well.
And with the assistance of the federal government, certainly at a municipal and provincial level in British Columbia, by way of example, is countering radicalization to violence is a key priority for the Ministry of Public Safety and Solicitor General's office in British Columbia. We're creating a hub approach to this issue because we've determined that we have to address it before it goes from if you will, young people becoming radicalized to actually acting upon those beliefs. So the hub approach is a venue for various community service providers to work together, and really with the aim to redirect individuals who may be on the path to radicalization.
Thank you very much. That's extremely helpful. I wanted to ask you a follow-on question. You've in a way preempted what I was going to ask about, but from your experience as serving police officers, in addition to serving on the Canadian Association of Chiefs of Police, what are the central levers at our disposal to mitigate the risk of being radicalized? And I say radicalized with respect to both the propensity to potentially be subject to a right-wing extremist group, as we saw with respect to the individual who committed the massacre in Saint Foy just over a year ago. No evidence that he belonged to a group, but there's certainly self-radicalization, one could say. And also Islamic terrorist groups. What do we know so far that would facilitate the work of preventing young Canadians from ever falling into this trap?
Well, we've taken a multifaceted approach within our police service. For example, it's about educating our police officers about recognizing the signs of radicalization, but probably the more effective means are really community engagement, making sure that our police services, especially the municipal and the closer to the ground, I know the federal agency, as Lawrence has pointed out, ultimately has authority for national security investigations, but it's the police of jurisdiction that's going to see this. So our engagement activities are about engaging the communities for a number of different reasons, not the least of which is to make sure that they trust us and feel that there's legitimacy with the police services so that they can confide in us if they see that members of their community are being radicalized to violence. The other piece is putting out education to these young individuals that may be getting a message from one side to say that there's some glory or there's something that's good for them to go to this act of violence. In fact, it's quite the opposite.
If I can follow up, I've only got a minute left with a more specific question along the same lines. Is there a pattern, a profile, not to say a stereotype, but a propensity that's identified so far that raises the risk of being radicalized or being recruited in terms of socioeconomic status, in terms of racial, religious, cultural background, in terms of networks that one does or doesn't belong to? Is there anything yet that we can use as a sort of marker for the way forward?
There and Lawrence can step in and correct me, anything I might say on this, but we've had this discussion at the committee level, and there's no specific profile of what a person that gets radicalizes looks like. Generally speaking, there are things where they are vulnerable, they perhaps feel disaffected, and they have no one, they don't trust people, and they're on their own, they're loners. That's probably the closest thing you're going to get to a profile, but as far as a specific socioeconomic or age, no.
So that's very helpful.
Okay,
Thank you, Mr. Chair.
we're going to unfortunately have to leave it there, Mr. Spengelman. Mr. Mott, 7 minutes, please.
Thank you very much, Mr. Chair, and thank you, Chief Martin and Deputy Rankin, for being here today. I want to go back to the comment you made earlier, Deputy, in regards to, one of you made in regards to peace bonds. Now, we know that Bill C-59 increases the threshold from is likely to is necessary to prevent a terrorist activity in order to even obtain a peace bond in the first place. So determining that a peace bond with certain conditions is necessary to prevent an act of terrorism is a pretty high bar. The amount of evidence that would go into proving that is nearly the same as to prove a criminal charge delay in information. So can you explain to the committee the importance of peace bonds and if you've used them, how often you've used them, and whether this, in your opinion, this new threshold could be a risk to Canadians with the increased threshold?
Yeah, I can give you, with respect, the RCMP has used peace bonds a total of 14 times since that they have records of, and 5 of which were the 810.011, which was the peace bond introduced as part of the Anti-Terrorism Act of 2015. So currently there's none in effect right now, but those are the numbers, the statistics. There's always a concern if the threshold is made higher. I think, you know, as I said, peace bonds are not the panacea. They're not necessarily going to stop it, but they can help control it and help mitigate it. It's not going to stop all threats. But yes, there's obviously a concern anytime the threshold's made higher, but we do feel that we have a number of tools currently that help us to detect, deter, and respond to terrorism in this country.
Deputy, anything further to add?
No, I see the benefit of them once they are imposed, though, is the ability to, among other things, conduct full-time surveillance on the subject if there is a GPS tracking involved, to interview the subject, to monitor the individual. And again, it's, as the chief said, it's effective in managing some of the threats posed by an individual, but there are limitations, as the chief mentioned in his opening statement, in terms of enforcing conditions such as access to internet when they're utilizing that computer device in their own residence.
Right, thank you. So we've got the peace bonds, but the other aspect now of C-51 or C-59 is the preventative arrests. And we understand in the legislation that it might be limited to is necessary, the language now, to prevent a terrorist activity. Under the old C-51, the threshold is likely to prevent, was the language that was used. In fact, the committee heard from the Justice Department earlier on this study and confirmed that the threshold, they confirmed that the threshold to make a preventative arrest was being raised, and they said that, and I quote, it would require the police to present evidence of a greater link between the conditions to be imposed on the person or the arrest of the person and the prevention of the terrorist activity, end quote. Now, again, similar to peace bonds, do you believe that this higher threshold will make it more difficult for law enforcement to make preventative terrorism-related arrests?
It could. It would be my simple answer on that. You know, the idea behind that, the preventative arrests and the recognizance, is really to give the police the time to determine whether the evidence is there to see if, in fact, they are planning a terrorist act, and of course allow the judges to assess the evidence to determine if something is there. So every time you raise a threshold, there is a potential.
If I could just add,
Yes.
I mean, the proposed increase of the threshold would limit the situations that this tool could be used, as it requires us to demonstrate the necessity in order to prevent terrorist activity. So yes, it would raise the threshold, and it would limit the range of our solutions.
Okay, thank you. I have a last question for each of you. I got about 3 minutes left. Now, You spoke, Chief, specific to the three concerns that you have as a committee, as a police association with respect to terrorism peace bonds, which we've kind of covered off, the intel to evidence, and the encryption. And so we've heard from a few witnesses so far at this committee who have expanded upon their thoughts and have given us some indication of what they'd like to see more or improved upon in this bill as it's currently written, which is why we're having the debate now before second reading, which we can make some changes, which is great. So if you were to change C-59 and that you think would be absolutely critical for public safety, and keeping in mind the balance between privacy and rights and privacy, what would those be, and how would they be accomplished? And I'd like to hear from both of you on that, if I could.
Well, if you're speaking specifically to the encryption piece,
Any aspect of this legislation.
okay. Well, I'll speak to the encryption piece, and I'll let Lawrence step in from there. But I think really it's, I know the debate with respect to privacy and individual rights versus the collective safety and well-being. I think really, as I said at the onset, it's about the principles of intercepting those private communications as opposed to the technology being used today. So that's what I would encourage the committee to think about as it goes over this bill. So, in the case of telecommunications companies, they are required to maintain this information for a period of time subject to proper judicial authorization to look at this information. That may not currently exist with some of the applications and things that we see nowadays. So how that is done, you're in a better probably position to answer that than I am, but certainly I would think to consider it. So it's about the principles of intercepting communication of people that intend to cause harm through terrorism or organized crime, as opposed to the technology used. So that, if I could sum it up very quickly, that's how I would ask the committee to consider.
This is on very quickly, about 20 seconds. Deputy Chief Constable Rankin.
Legislative reform is required to keep pace with the changing technology. That's the bottom line. Everything from data preservation standards for corporations that hold data, they're getting shorter and shorter. It's more of a challenge for police to collect that data. And again, enhancing powers to enable domestic production orders for foreign data. And advocacy for effective lawful access. We recognize that some ability to access evidence when judicial authorization is granted is required. We can look to Australia, the European Union, in terms of what they're doing in terms of cybercrime legislation. We recognize that secure data and communication enables commerce and social interaction in today's reality, but when we have a court order and we can't get access to information on a computer that's judicially authorized, that's a problem for the police, and it's going to be a jeopardy not just for national security, but organized crime in every other facet. And I think more so than now than ever before is every crime we seem to investigate, whether it's got a national security component to it or not, has a cyber-enabled component to it. And the challenges that we're facing are, at times, they seem to be insurmountable. So a balance has to be struck, and I recognize that we need if we're given access to enter a house with a court order, we can enter a house, but we can't enter a computer. If it's
Thank you, Mr. Motz. Mr. Dubé, 7 minutes, please.
Thank you, Chair, and thank you both for being here today. One of the issues that came up in the previous Parliament when we debated C-51 was a lot of talk is given to legislation for keeping Canadians safe, but often one of the pieces that's forgotten is actually providing proper resources for police. And one of the things that comes to mind is the police recruitment fund that existed to help from the federal government to help provinces, municipalities, as you obviously well know, and provide additional funding, a fund that was cut, that's never been brought back, that we wish would be there and be permanent. How important are actually having resources beyond all the talk of legislation and all the procedures, just knowing that you have the ability to properly equip and train and have those men and women on the front lines in order to keep Canadians safe?
Well, that's a very good question. Both, I've had discussions with our colleagues at the RCMP throughout the province and, of course, nationally through this committee, and then, of course, locally. I would suggest to you that this type of threat that we're seeing with terrorism, which a lot of people would attribute the watershed moment to 9/11, has really drawn on our resources. And I know for a fact, whether it's the RCMP or whether it's locally, we've had to redirect resources from other things in order to address this ongoing and serious threat. And depending on world events, that's scalable. It moves up and down depending on what's going on in the world. So we've dedicated resources to counterterrorism and anti-terrorism, but have not been able to backfill or replace those resources behind that to deal with other things more traditional, such as organized crime and other things that the police deal with either jurisdiction or federally. So it is very much an issue, and it's one of those things where you know, to use the analogy, you can only spread the peanut butter so thin, and then what happens when things start to fall between the cracks. But I'll turn over to Lawrence before I get on my pulpit.
And just on the heels of the chief's remarks, looking at again from a municipal perspective, we're attempting to increase our number of secondments to E-Inset, so the RCMP E-Division Inset unit. We currently only have 2 members seconded. We're trying to go to, we're going to be going to 3, but I would like to see that increase even greater. Within the Vancouver Police Department, over the last 6 years, we've increased the number of files that my unit that looks into counterterrorism, national security files from 13 files 6 years ago to 268 files without an increase in our staff. In fact, a decrease because, as Chief Martin pointed out, we're having other issues like a regional gang war that's going on right now. So we're very much stretched to the limit. And so we're called upon in the first instance to look at potential bomb calls, anti-government remarks regarding ISIS or Al-Qaeda, suspicious circumstances such as people taking photographs of critical infrastructure, and then individuals that are involved in terrorism or radicalism. We, as the police of jurisdiction, will look at those files initially, and if they meet the threshold for national security, then they're forwarded to the INSET. But it's just, you know, we're doing a lot of the training ourselves in-house, whether it's counterterrorism information officer training, project or Operation Securus, working with private sector to train businesses to become familiar with what to look out for in terms of potential terrorist threats. That said, our relationship with INSET has probably never been better, but it's just that we're all, and I will include, I won't speak on behalf of the RCMP, but certainly at our end, we're spread very thin.
And the hypotheticals are always a dangerous thing in this line of work in politics, but I'm wondering if there's any way you can, or even as a thought, and you might not want to go down this slippery slope, but how many of these cases would be dealt with just simply by having the more resources to deal with them, as opposed to actually bringing in legislative change?
Well, from my perspective, it's about dealing with things in a more timely manner. I don't know if we'll always redirect and redirect our resources to the higher priorities, but sometimes the things, if they're not at the highest priority, they may take a little bit more time to respond to, so obviously we're going to respond to them quicker. And I think, you know, the question came up about, it's not just returning foreign fighters, it's not just radicalization to violence, that we've seen on the internet, but you know, right-wing extremism is been in this country. It's rising again. We've seen it in the United States and some of the acts there, and of course in Quebec. So you know, all these things are happening all at the same time. So I think, to answer your question simply, it's about dealing with more priorities in a more timely fashion if we had the resources to do that.
And if I may, just quickly, because my time is wrapping up, you mentioned intel to evidence, but there's also this issue with regards to even terrorism charges. So even with the situation in Edmonton, if I'm not mistaken, it's not even, the terrorism charges in many of these cases become moot because the other crimes that have been committed, the different forms of violence provide enough charges where, the prosecution can proceed without having to go down that path. How challenging is that? Just this notion of actually identifying what is or isn't terrorism, and how does that pose any challenges for the work that you folks do?
Chief, if I can jump in.
Go ahead, please.
So, I mean, when we're looking at it, the point you just made is that to prove a component of a threat to security of Canada, we're looking at having to demonstrate or collect evidence that demonstrates that the crime was motivated by political, religious, or ideological objectives within Canada. The issue we have is that, and you've again appropriately noted, is that investigators now are looking at an offense that involves perhaps the murder of an individual. Well, there could be a national security component. The elements of that traditional offense for murder are met, and that investigation is launched. The other issue we're dealing with now, whether it's traditional crime, if you will, and national security or terrorism, is that we have the Jordan decision of the Supreme Court of Canada, which sets prescribed timelines from a moment a person is arrested and charged until they're convicted. So the clock is ticking for collecting evidence. And if we have the evidence at hand to prove a murder charge versus having to dig deeper to prove, collect the evidence for political, religious, or ideological elements of that offense, that poses a challenge, and the police have to make that decision. Of course, it's in discussion with the RCMP because of the nature of the act, but those are the challenges that we face. And if I could just add one more thing, the additional challenge.
Can you add one more thing and another question,
Sure,
possibly in response
certainly.
to Ms. Damoff, who now has 7 minutes, please? Thank you.
Thank you very much, Chair. And I just want to start by thanking you both for your service and for being here today with your testimony. It's much appreciated. I first want to start on the encryption piece, because when we were doing our study on the national security framework, the chiefs of police were here talking about the need to have access to encrypted data. And then when we subsequently went on the road with the committee across Canada and had further witnesses, we heard overwhelming testimony that encryption isn't what we used to think about during the First World or Second World War, where it's encrypted data and somebody breaks the code and everything's good. That it's actually when we give a backdoor to the good guys, like you folks, we actually are giving a backdoor to the bad guys as well. And I've had numerous conversations with people who work in that field who said that's absolutely true. So you're in a bit of a conundrum here that you don't want to make it easier for the bad guys to have access to data. So I'm just wondering if you want to comment on that, and if there's anything in this legislation that would be able to assist you without also assisting the bad guys from getting access to data. And either of you would be fine.
Want to take the lead on that, Lawrence, or shall I?
Well, I'll start. I guess I don't know if there is an easy answer to that question. I say that the barrier of encryption prevents us from obtaining a full picture of the evidence that is in the possession of the individual that the police are investigating. And I've talked to some of my tech crime people, and they say you can have an encryption technology today that will eventually be defeated, and there'll be a workaround, or through research we'll be able to find a way to, if you will, a backdoor way to defeat the encryption. But I think that whatever we will come up with, the bad guys, if you will find a way or discover in the same manner. I think what we find now is we find the police are simply not equipped to deal with it as effectively in some cases as the bad guys, and that's the position that we find ourselves in time and again.
Thank you. We talk a lot when we're talking about terrorists about, we've already brought up 9/11, ISIS, Al-Qaeda, that side of it. And certainly you were talking about the far right, and we've seen it in Saint-Froid, in Las Vegas, in the United States, and we tend to not focus on that. And I'm just wondering if you could comment on the challenges you're facing. I know when the minister was here, he said these type of acts are lone wolves, and they're very difficult for law enforcement or public safety to deal with these lone wolves who've been radicalized. But we are seeing quite a few of these radicalization to the far right, and we don't talk about that one quite as much. So can you maybe either of you speak to that?
Well, I'm fortunate to live in a jurisdiction where one of our academic professors up at the university is a subject matter expert in right-wing extremism, so I have a little bit of knowledge from her. And the one thing about right-wing extremism, it cannot be underestimated here or elsewhere. The biggest difference that my understanding is between right-wing extremism and what we're seeing from Islamic extremism is really how organized they are. So when you talk about them being lone wolves, perhaps a little bit more to that, but not quite as organized nationally and internationally perhaps as others. So that's really the biggest difference, as I understand it, but it cannot be underestimated, and it is still a threat within this country and elsewhere.
Thank you. I've got about 3 minutes left. Just turning to the legislation itself, sorry. We have had testimony on this, as well as an open letter that was talking about the new offense that was in Bill C-51 on advocating or promoting the commission of terrorism offenses in general, and the broad definition of terrorist propaganda. And when we had the minister here, he talked about how in Bill C-59 we've amended that wording because it was actually too vague, and that no charges had been laid because they weren't enforceable in court. So I'm just wondering, do you feel these changes will assist you in actually being able to lay charges that can be enforced in court?
It is a change. It's a bit of a different threshold, and but counseling to an offense has a firmer position in law than what we see with advocating. When you talk about advocating, probably the closest thing I can think of is the hate crime legislation. When you talk about that, and there has been rarely, to my knowledge, but certainly some activity or some prosecutions under that legislation as well. So I think from my perspective and with the CACP is that counseling has a firmer place in law and probably is going to be in a better to move forward should we want to lay those charges.
Because we certainly want you to be able to lay charges and then have them go through when it gets to court, right? So
it's going to be a little bit more restrictive as opposed to just generally advocating on YouTube and promoting it, but it will probably, from what we can determine, more successful in the end.
Okay. We also heard about challenges because of law enforcement working in silos. So you've got the RCMP, you've got CSIS. Do you think the National Security and Intelligence Review Agency that's created in C-59 will help ensure that information will be shared in a timely manner, or have you looked at that aspect of it?
About 30 seconds to answer that question.
What I do know is that at the National Security Headquarters, there's a constant flow of information between CSIS and the RCMP. The only thing I've ever heard of from my own jurisdiction is that the disclosure letters and go directly to the RCMP. They don't share it with other intelligence agencies to support it. For instance, the Provincial Anti-Terrorism Squad here in Ontario. But I do know through that National Security Headquarters is that there is this constant flow of information between the RCMP and CSIS. So I think the information flow is very good there at the top end, at the federal end. And then it's just what it takes to move from the federal to the rest of the agencies across the country.
Thank you, Ms. Demoff. Mr. Paulus, now generally Mr. Paulus asks his questions in French, so the earpieces are available. Are you all right, Chief Constable Rankin? You're all right for the French questions?
I don't understand French, so I don't have an earpiece with me.
Okay, you'll get the trick. Okay, Mr. Paulus, 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you, gentlemen, for being with us. Your testimony today is very substantive when it comes to national security, and the key purpose is to determine whether C-59 will continue to enable your law enforcement agencies to do their job. It's my understanding to date that you have a number of misgivings concerning terrorism and the returning of Islamic foreign fighters. On the one hand, the government has confirmed, without really elaborating on that, that there have been a number of measures put in place, but that there is a more wide-scale problem. Could you elaborate on what the problem is? Is there a communication problem between Canada's intelligence services, the RCMP, and your police forces, which are more regional in nature?
I wouldn't say that there's an issue with respect to communications. If you're talking specifically about the returning foreign fighter phenomenon, it's not so much the information sharing that's causing the problem. It really comes down to more the question from Mr. Dubé is that do we have the resources if they come back en masse, do we have the resources to then determine what their activities are within this country and if their intent is honorable or not. So, at times we've had, and different countries have experienced greater numbers than Canada has, but when the returning foreign fighters come back here, we have to make sure, determine what they're up to. And if there hasn't been anything right now, as I understand it, there's only been, and I can check the numbers, very few people that have been charged in absentia or have been charged after they've returned back here because we had the evidence to support the charge when they returned back to the soil. So a lot of these people are returning from theater. We don't know what their activities were in their entirety, but we knew that they were there and they were up to something. So we don't have the evidence to prosecute. So it becomes down to, as Deputy Rankin said, do we have the resources to do surveillance and make sure that they're not carrying on activities that are going to be harmful to Canadian citizens? Lawrence?
Yes, the numbers are 4 high-risk travelers have been charged in absentia. And again, as Chief Martin has said, trying to collect the evidence from what the foreign fighters, for example, were up to overseas is difficult in a theater of war. Second is we may collect the evidence or be provided evidence or information or intelligence, but with a series of caveats so that we can't use it, because the fear is that the individual who provided that information their life may be placed in jeopardy, or investigative techniques that are being used by an agency may be released. So oftentimes information is given to the RCMP, who in turn may give it to police of jurisdiction, but it's basically kept in secret because of the caveats that that are in place. And ultimately, what we're looking at is if we do lay a charge against an individual, all this information that has been collected, that's been utilized by the police of jurisdiction or the RCMP, has to be disclosed in court. So these are the hurdles that have to be overcome before we can have a successful charge. We have to look at all these factors. And can that investigation stand on its own if we peel away certain pieces of information that can't be released in open court?
Merci. Maintenant, vous avez...
Thank you. We just spoke of those who are abroad, engaging in jihad and returning to Canadian soil. That's a problem, but there's another long-term problem in Canada. You mentioned in Vancouver, you went from 13 files to 268 files, individuals that were identified, and you talked about a problem, lack of resources. Today, we need to know, when it comes to the Bill C-55, are there any provision in this bill that might reduce your legal ability to intervene in these cases? For example, to seek a warrant from a judge were there to be a possibility of a terrorist offence being committed. Under C-59, are there any provisions that are problematic that may hamper your work on the field?
Question, unfortunately, you have about 20 seconds to answer it.
Well, I think we've addressed it to some degree, but I think, yes, whenever you raise some of the thresholds, it does make it a little bit more difficult to convince a judge that we need to proceed with this. So anytime the thresholds are raised, it could cause some issues. That remains to be seen. But having said that, we do have a lot of tools at our disposal currently to fight terrorism in this country.
Thank you, Mr. Paulus. Mr. Fragiscatos, 5 minutes, please.
Thank you, Mr. Chair. I just want to go over something we just heard now, just for all of our understanding. Without clear evidence, it's hard to arrest, prosecute, and convict suspected foreign fighters, correct?
Yes.
Okay. And that was the case under this government and under the previous government, because a number of foreign fighters returned under the previous government.
Yes, and that's going back to my point about the three issues, is that it's the intelligence to evidence conundrum, really. It's and Lawrence spoke to it a little bit more eloquently than I, but it's some of this information that's gathered in theater It's difficult, first of all, to protect the identity of the individuals who are providing it, where it's coming from, and the caveats behind this intelligence. It can't be used as evidence. So that's where the problem lies.
I don't mean to interrupt you. I just have 5 minutes and a few questions, but thank you very much. And you're talking about, in theater, very difficult to extract evidence from conflict settings such as Syria or Iraq or countries in that kind of situation. My colleague, Mr. Motz, brought up the matter of preventative arrests. The preventative arrest measure, first introduced in Canada in 2001, has never been used, correct?
I don't have that.
Just quoting legal analyses, a number of commentators. We've heard from Professors Roach and Forsays at this committee who've examined this and been very clear that the preventative arrest measure has never been used.
That's correct.
Okay. Now, a higher threshold was indeed put in place in Bill C-59. That responded to a long-standing concern among civil rights advocates who were of the view, and I think it's a reasonable position to hold, to detain someone without a warrant for up to 7 days without applying a criminal charge, as the preventative arrest measure allows for, is questionable. You can in a democracy you can at least have that debate. What the government has done is look at C-51 and introduced a change. So under C-51, as we heard, an arrest could happen when it was, quote, likely to prevent a terrorist act. Now in Bill C-59, an arrest can be made when on reasonable grounds there is suspicion to believe that a terrorist act might be taking place. So you still have that ability to lay an arrest, and in emergency situations, it's there. It's not. This isn't preventing you from acting as police, correct?
It just changes the threshold, as you pointed out.
Okay, thank you very much. We heard from the BC Civil Liberties Association a few days ago, who told us, a number of concerns, but in a subsequent article that was written since their testimony, there was concern expressed about Bill C-59 on cyber operations that could be conducted by the communications security establishment. And since you focused today a great deal on the technological aspects of terror and how that can jeopardize Canadian security, I wanted to ask you about that. Their view is that C-59, by empowering the CSE to conduct cyber operations against foreign actors, constitutes a danger. Specifically, it would normalize state-sponsored hacking. But can you speak again to the importance of cyber operations from a security perspective? How critical is this? Because the nature of security is changing. Canadians deserve to be protected, and we have to make sure that our approaches are keeping up with changes that are underway.
I think the simplest way for me to sum it up is Lawrence mentioned it, but really nowadays either technology is the target or it enables the crimes to be committed. So it is in everything that we do and everything that we encounter from a policing standpoint is involving some form of technology at this stage of the game.
So you would agree that with going down this road, allowing CSE to conduct cyber operations against foreign actors is a welcome change.
I can't speak. Go ahead, Lawrence.
I can't speak for the CSE, but I would say that if you're looking at it from law enforcement in Canada, we're having to seek judicial authorization to obtain this information, and we're being challenged by day and again by encryption. So we're not arbitrarily going in and searching people's computers without the requisite permission or authorization. What CSEC is doing and what we're doing are really two different things. So I'm not in a position to comment on that. I am in a position to say that we've got a number of challenges, encryption being one of them, and trying to collect that evidence in a timely manner. And legislation isn't keeping up. Technology is speeding ahead, and we're having to adhere to court decisions out of the Supreme Court, such as Jordan, that places additional burden on law enforcement to try to
Thank you,
Mr.
Fragiscatos. You always ask the most difficult questions at the end. Mr. Broussard, welcome to the committee. 5 minutes, please.
Thank you, Mr. Chair, and I'll get right into it. We have, as an opposition, been asking the government on numerous occasions with respect to the returning foreign fighters. And one of the responses that was given by Minister Goodale is that our government uses a variety of tools to combat terrorism, including the Global Coalition Against IS, security investigation, surveillance monitoring, intelligence gathering, lawful sharing, collection of information. He also said peace bonds. And one of the things that you said, Mr. Martin, that was quite disturbing to me was the fact that currently there are 0 peace bonds that exist in Canada, and yet there are returning jihadists that we're aware of. We're not aware of the exact number. Do you find that problematic, that we're not issuing peace bonds to monitor returning jihadist terrorists at this point?
There would have to be a threshold in order to get a peace bond for one of these individuals in the first place, so they'd have to demonstrate something. I can't speak specifically to any specific cases or things that are being looked at, but yeah, currently there's none in effect right now, but there have been, and should it be appropriate to do so, and we have the evidence to get it, then that's what we would be seeking.
So my question then is, if this piece of legislation asks for that threshold to increase from where it was previously, is there the potential or the risk that law-abiding Canadians are being placed at risk at this point, given the fact that we are aware, the government is aware, that there are returning jihadists? We don't know the number, but we know they're out there. Is the Canadian public at increased risk because of the increase in that threshold?
Well, any increase in threshold will make it a little bit more difficult for law enforcement to potentially get a peace bond. What we'd have to use is one of the other tools at our disposal, and perhaps that is surveillance, or it is some other form of other tool that is available to law enforcement that we could use at that time. So, law enforcement, and I can speak, I'm sure I could speak for our CMP brothers and across this country, is that we're not going to allow Canadians to be at risk if we can do something about it, and we have tools at our disposal.
And I want to go back to something you said earlier about resources. How stretched are your resources currently to deal with this issue?
Well, we are my service specifically is stretched to the maximum. Dealing with traditional crimes, as Lawrence would describe them, homicides, those types of things, and increases in certain types of crimes, and then dealing with these emerging issues, human trafficking, terrorism, all these types of things that are relatively new on the horizon, is stretching us to the limit. But we try to prioritize and triage these types of investigations and make sure that we deal with the ones that are most imminent.
Okay. Thank you. That's all I have.
Thank you, Mr. Broussard. Monsieur Picard, 5 minutes, s'il vous plaît.
Thank you. I had a lot of questioning, and something popped up in my mind, and my colleague here has suggested a very good idea. Patrolmen and women have the challenge of being on the street and facing everyone on a daily basis. Based on that knowledge of what goes on the street, what is your interpretation of the level of risk or danger the Canadian population is based, as this change raised or decreased over the last, let's say, 5-6 years?
What is my assessment of the risk to frontline officers? No. To the public?
Well, does the Canadian population is more at risk now than it was 6 years ago?
I would suggest to you that with the returning foreign fighters, the prolific use of the internet to try to cite people or get people to radicalize, I would suggest to you that, yeah, in my estimation, that the risk to the Canadian public is higher than it was 6 years ago, 7 years ago.
Does this situation is, to your knowledge, very recent, or we did start to look at those issues 5 years ago, like internet, for example, propaganda. And have you encountered cases? Have you looked at cases where, well, we start to see internet more internet propaganda messages without knowing how to qualify one person traveling abroad? Well, apparently we are in a situation of a possible foreign fighters if it came back. We didn't start to look at that last year, did we?
Chief, can I just interject?
Yes.
So, I mean, I think what we're looking at more so now than even in the last few years is that the if you will, the end of what appears to be the end of the caliphate, and then where do these fighters go? And I think what you're seeing in Europe and in the UK, what you're seeing potentially and over in the United States could very well be reflected in what we in Canada. But I think that is the issue, is that foreign fighters are coming back, or others that we may not be aware of as of yet because they have nowhere else to fight. So that is becoming more prominent.
So that triggers, I guess, an interest in the exchange of information between the different levels of police forces. Does the security clearance is an issue in those communication?
Well, at the municipal level, the members that are liaising with INSET, the RCMP, have top secret security clearance. But again, the information is going from National Security Headquarters to the respective INSET, and then we are updated on certain files on a regular basis. But our members that are working on these types of investigations from a municipal perspective are liaising with our INSET investigators on a regular basis and exchanging information, providing them with information.
Does the need to know basis limits you to when you approach someone as you expect, if you expect the person to be a potential foreign fighters, does the fact that the needed to know basis quite maybe limit some information accessible to you? Does that change your position and the means you have at your disposal to act toward this person? Because what is your interpretation of what we call a foreign fighters from the street standpoint, the patrol person standpoint? When you look at someone and say, I know that he might be a foreign fighter, so what can I do? What are the means at the disposal of the police force on the street then?
Well, I think part of it, certainly we're finding it, and we've embraced training related to that frontline kind of encounter within our own department. And it's sponsored largely by the RCMP with the First Responder Terrorism Awareness Program that's providing training throughout the country. So frontline officers are aware of what to look for with respect to potential foreign fighters. And again, not just with Islamic foreign fighters, but right-wing extremists as well.
Thank you, gentlemen.
Thank you, Mr. Picard. For the last few minutes, Mr. Dubé, please.
Thank you, Chair. Deputy Rankin, I just want to go back to a comment, and I apologize if I'm not paraphrasing this properly, but did I hear you correctly earlier when you said that even with a warrant, you couldn't gain access to laptops or computers or things like that?
Yes.
And can you explain what you mean by that?
The encryption on the device, whether it's a phone or a computer, is such that we don't have the technology that would allow us to circumvent or overcome the encryption. So what evidence that could be contained within that device is kept from us. So that's one issue. And then what we'll find in investigations, and I can speak more from traditional criminal investigations, is that we will then often liaise with other police agencies, including the RCMP, to determine if they had technology that could assist us in defeating the encrypted device. But that is a significant issue from a criminal investigation, but it would also have impacts on national security investigations where we lay a criminal charge and then only discover a year later, when we're able to get into the device, additional compelling information or evidence, and that we may not be able to disclose that information in a timely manner without jeopardizing the charge.
And if I may, thank you. And if I may, just my time is limited. So if I just, and the comparison might not be appropriate, but if you look at the border, the debate that goes on about looking at people's cell phones at the border, many have argued that the having a cell phone is not like having a suitcase. So when you cross the border, you have an expectation that your suitcase will be searched, that it's okay to look through clothes and things like that. Whereas on a cell phone, you can have banking information, you can have health information, all kinds of information that puts someone's privacy in jeopardy in a different way. And so notwithstanding any crime that may or may not have been committed, is there concern about accessing, for example, laptops and phones, and then by decrypting that, you're gaining access to a whole swath of information that casts a fairly large net?
Very briefly, please. Thank you.
There is a danger in that, and I think what we have to do is we have to be very precise in terms of the affidavit that's being drafted to gain access to that device, and the understanding that of the justice or magistrate that's issuing that warrant, that we're prescribed in terms of where we can search and what data that we could look at.
Thank you, Mr. Dubé. That'll have to bring our session to a close. On behalf of the committee, I want to thank you, Chief Martin and Deputy Chief Constable Rankin. Your testimony has been very valuable to the considerations that this committee is undergoing. So with that, we'll suspend and re-empanel. Come back to order. We have as witnesses the Canadian Bar Association, represented by Mr. Endelman and Ms. Carter, and as an individual, Christina Shirley from the Atlantic Human Rights Center, not presently here. So we'll go with Canadian Bar Association and look forward to your presentation. I understand, Ms. Carter, you're to go first.
Thank you. Thank you, Mr. Chair, honorable members of the committee. My name is Jillian Carter, and I'm a staff lawyer with the Law Reform Directorate at the Canadian Bar Association. Thank you for inviting the CBA to discuss Bill C-59 with you today. The CBA is a national association of over 36,000 lawyers, notaries, law students, and academics. An important aspect of our mandate is to seek improvements in the law and the administration of justice, and that is what brings us here today. The CBA has offered its views and expertise at many stages in the development of Canada's national security and anti-terrorism regime. Our written submission on Bill C-59 was prepared by multiple sections of the CBA, including the criminal justice section, immigration law, charities and not-for-profit, military law, and privacy and access to information law sections. With me today is Peter Edelman, a member of the immigration law and criminal law sections, and a lawyer specializing in immigration law. I will now turn it over to Peter to address the main points of our submission. Thank you.
Merci beaucoup de l'invitation de venir comparaître.
Thank you very much for the invitation to appear before you today. Bill C-59 sets out a number of substantive updates for national security, and it responds to a number of decisions from the Federal Court of Canada and a number of ongoing concerns regarding Bill C-51 from 2015. The Canadian Bar Association generally supports the structure and provisions of Bill C-59, which it sees as a positive change to modernising Canada's national security framework and enhances the transparency, oversight and review where there were lackings in the past. So our comments regarding the proposed amendments to Bill C-59 are with a review to further improve the legislation.
Specific recommendations, and I would refer you to those for the more technical amendments we propose. I will use my time today to focus on 2 or 3 areas of broader concern. First of all, we support the creation of the National Security and Intelligence Review Agency, the NSIRA. While we commend the decision to avoid, and I just have a couple of comments with respect to it, but in particular with respect to the mandate. While we commend the decision to avoid language that would unnecessarily restrict the agency's mandate, an overly broad mandate could hinder the agency's ability to focus and assess its performance against its mandate. So in the way that it's drafted now, the NSIRA has responsibility for broad review of any activity of a department that, quote, relates to national security or intelligence. Intelligence is a very broad term that could include things that are done by anything from the Canadian Revenue Agency to Fisheries and Oceans, police departments, etc. National security is also problematic given the multiple definitions that we see in different pieces of legislation. In particular, we remain concerned about the SCISA, so the Security of Canada Information, or the Information Sharing Act, or with the amendments that we have today, is that the breadth of the definition of an activity that undermines the security of Canada in Section 2 is still very, very broad, and notably it's different than the definition in the CSIS Act of threats to the security of Canada. And having 2 definitions is not helpful, it's confusing, and it doesn't provide a clear mandate for national security agencies, and in particular for an oversight or review agency. I would also note in passing that the amendment to Section 2, Sub 2 of the SCISA is troubling, as it actually substantially reduces the protection under the current version. So several legitimate political activities might be seen on their face as undermining the sovereignty or territorial integrity of Canada. So in the past, we've recommended that there be one coherent, clear definition of national security, and we continue to be of that view. It's also unclear whether certain other activities fall under the definition of national security at all. For example, the Secure Air Travel Act does not refer to national security, and it's unclear whether the review of SATA activities would fall under the NSIRA or not. In other words, is this national security legislation? Does it fall under NSIRA? The coordination of the work of the NCIRA with other review agencies is obviously key, and although we would note that there remain significant gaps in the review framework. The problem is particularly stark with the Canada Border Services Agency, and we've expressed concerns about this lack of independent review of the CBSA in several past submissions. CBSA remains one of the largest law enforcement agencies in the country and has no independent oversight or review at all. This is not a role that NCIRA should take on, although it does highlight the problem of having a vague definition of national security, because arguably everything the Canada Border Services Agency does could fall into a broad understanding of national security in a vague sense. Everyday complaints about problems at the border should not be burdening NCIRA and its resources. A specialized review agency is required. We also have concerns in particular with respect to NCIRA's access to information, and in particular that NCIRA would have access to any information other than a cabinet confidence that it deems necessary to conduct its work. This would extend explicitly to information subject to solicitor-client privilege, professional secrecy of advocates and notaries, or litigation privilege, creating an open-ended mechanism to review legal advice given to the government. This is of significant concern to the CBA. The role of solicitor-client privilege is fundamental to the functioning of our justice system, and this is as true for government actors as it is for private actors. It has been argued that privileged information must be made available because the practices of security agencies often depend on the legal advice they receive. However, without assurances of privilege, legal advice will be sought less often, will be based on less candid disclosure by client agencies, or worse, sought and received but not documented. The other problem with respect to the disclosure of solicitor-client privileged information is how the NCIRA then deals with it in its reports. And so it's not helpful for the NCIRA to have solicitor-client privileged information. What they need is information about how this is actually deployed in the agency, not the advice that was given behind those decisions. The Intelligence Commissioner, the CBSA supports the creation of an independent specialized office for the oversight and authorization of activities by the CSE and the CSIS. We have generally called for judicial oversight, but we recognize the advantages of a dedicated commissioner with staff and resources to allow effective ongoing oversight. The nature of the review mandated by sections 14 to 21 of the proposed Intelligence Commissioner Act do create some concerns for us, because there's a system of nested reasonableness findings. And so instead of the normal process in front of a judge for a warrant where a judge would find on reasonable ground, whether there are reasonable grounds to issue a warrant, what the Intelligence Commissioner appears to be, or what the legislation currently foresees, is that the minister would make a finding on reasonable grounds, and then the Intelligence Commissioner would review that on a reasonableness standard. That creates two problems from our perspective. One, it's unclear how much deference that implies. And there's an extensive debate in the courts right now around the application of the reasonableness standard at all, and how that plays out in terms of deference. And there's no need to bring that confusion into this area. Secondly, and there is not that confusion around the reasonable ground standard. And so there's no reason for this nested reasonableness finding other than creating a level of confusion as to how much oversight is actually being provided, in particular because it's going to be provided behind closed doors. It's important for Canadians to understand what the Intelligence Commissioner is doing, and that be clear. With respect to the CSE, the CBA generally supports the more detailed mandate of the CSE. And we support the structure as it's being proposed. There are several elements of the proposed mandates that are in tension with each other, in particular, the offense and defense in cyber operations. We would recommend that there be an explicit vulnerabilities equities process as part of the mandate of the CSE so that that balancing can happen in a transparent way. The U.S. has a process in place that might work as a model, or at least give ideas with respect to that. With respect to the CSE, we continue to have, with respect to CSIS, we continue to have concerns around the disruption powers, and in particular, giving kinetic powers to the CSIS comes away from the mandate of creating CSIS in the first place after the MacDonald Commission. I'll refer you to our written submissions with respect to our concerns around Section 12.132. We continue to have similar concerns that we've had in the past with respect to these warrants limiting charter rights in that context. And finally, I would note that with respect to the criminal code provision of counseling a terrorism offense, in my view, following the jurisprudence of the Supreme Court in Hamilton, the counseling offenses in the criminal code already cover everything this offense covers. There is no need to further complicate the criminal code. It's already too complex. It ought to be simplified, and the counseling offense covers everything you're hoping to cover here. Thank you very much for your time, and I apologize if I went a little bit over.
Thank you very much. And now that Ms. Shirley,
Believe
okay.
it or not. Yeah.
All right, has arrived from the Atlantic Human Rights Center at St. Thomas University. You have 10 minutes, please.
Thank you. Mr. Chair, Mr. Clerk, and honorable committee members, thank you for the opportunity to testify before you regarding Canada's national security framework. Following a set of national consultations regarding the Anti-Terrorism Act of 2015, formerly Bill C-51, the Liberal government drafted Bill C-59, an act respecting national security matters, to replace the Anti-Terrorism Act. I've reviewed the bill and will comment on it through a human rights lens. Securing the safety of its populace is a fundamental function of government. It's without question that government and its agencies must be equipped with the means necessary to prevent, counter, and address evolving threats in the digital age. In that same vein, a balance must be struck between securing public safety and respecting rights, ensuring any limitations placed on rights are necessary, proportionate, and reasonable. As a human rights professor, I'm pleased to see language recognizing the need to maintain respect for the Canadian Charter of Rights and Freedoms, the rule of law, accountability, and transparency within Bill C-59. The establishment of a National Security and Intelligence Review Agency with a mandate to review national security activities, consider complaints, and advance investigations is arguably the most significant advancement. The bill also establishes an intelligence commissioner to review the reasonableness of the Canadian Security Intelligence Service and Canadian Security Establishment authorizations regarding inter alia, intelligence gathering, and cybersecurity. Though Bill C-59 has addressed some shortcomings found in the Anti-Terrorism Act of 2015, concerns remain regarding its impact on human rights, particularly the rights to privacy, freedom of assembly and association, freedom of expression, liberty and security, democratic rights, due process rights, and anti-discrimination protections. Due to time constraints, this testimony focuses on concerns with amendments to the Canadian Security Intelligence Service Act regarding the collection, querying, exploitation, and retention of data sets. The Act defines a data set as the collection of information stored as an electronic record and is characterized by common subject matter. A data set could thus encompass any thematic electronic documentation, provided it is a publicly available data set, relates primarily to non-Canadians living outside of Canada, or constitutes an approved class. Though it is reassuring, a newly established intelligence commissioner would review classes of datasets to safeguard against abuse, the remainder of Section 11.05 subsection 2 is read with caution. Use of the term publicly available dataset is misleading, as it can include information that's considered private under the Privacy Act, but is available in the public arena, potentially without the consent or knowledge of the person concerned. In other words, publicly available data can extend to private information, public on request, by subscription, or by purchase. Rather than exploit this vulnerability by legitimizing and encouraging the commodification and exploitation of the public's data, the Government of Canada has a positive obligation to protect its populace against infringements by third parties that may compromise individual privacy in exchange for profit.
Granting government authority to collect publicly available data appears innocuous, but can reveal highly personal information in violation of the right to privacy. I also caution Canadians against blindly accepting mass government surveillance of foreigners. Though targeted surveillance may be necessary to thwart legitimate threats to peace and security, mass surveillance opens the door for foreign nations not accountable to Canadian voters to collect information about Canadians and share it with other governments, and share it with our government, other nations, or corporations. Under these circumstances, the Government of Canada could also place foreigners in danger by revealing compromising information to governments with poor human rights records. Differential respect for the privacy of Canadians versus non-Canadians outside of the country also constitutes a violation of non-discrimination under the International Covenant on Civil and Political Rights. The United Nations Special Rapporteur on the Right to Privacy has maintained that the distinction between one's own citizens and foreigners is not in compliance with the principles of the universal right to privacy. Failing to properly restrain state invasion of privacy could prompt charter violations of Section 8, protecting against reasonable search or seizure, or the presumption of innocence under Section 11, subsection D. In order to satisfy that such limitations are demonstrably justifiable in a free and democratic society, the onus is on the Government of Canada to prove these limitations are of sufficient importance, rationally connected to the objective, minimally impair rights, and produce an outcome that outweighs the gravity of the problem it seeks to address. Though protecting public safety and national security is of sufficient importance to warrant a well-defined, targeted invasion of privacy, the mass collection of data that could lead to results that are relevant to the performance of CSIS's duties and functions is not sufficiently important to encroach on constitutionally protected rights. Similarly, blanket collection of data sets merely relevant to the duties and functions of the service fails to demonstrate a direct rational connection to protecting public safety. If there's no direct connection to maintaining public safety and national security, why does the Government of Canada consider these proposed powers to be a necessary component of the national security framework? The United Nations Special Rapporteur on the Promotion and Protection of Human Rights while Countering Terrorism has warned that restrictions falling short of being necessary constitute arbitrary interference with the right to privacy. The Special Rapporteur further stressed that for a restriction to be permissible, it is not enough that it serves one of the enumerated legislative aims. It must also be necessary for reaching that legislative aim. Given that the aim of Bill C-59 is to protect national security, the blanket collection of any data relevant to the work of CSIS does not satisfy this test. Information respecting the protection of public safety and national security in Canada should be narrowly defined and collected only to the extent that is strictly necessary and when there are reasonable grounds to suspect a threat to the security of Canada. If we allow the bulk collection and storage of personal data without a person's knowledge, consent, or ability to challenge the nature and authenticity of information collected, the next step could be to misuse, alter, deliberately conceal, or manipulate information. Indeed, the Canadian Security Intelligence Agency Act allows the CSIS director to authorize designated employees to commit direct acts or omissions that would otherwise constitute offenses in carrying out their duties and responsibilities. Theoretically, the minister could authorize the collection of data sets intended to assist CSIS employees with carrying out otherwise criminal activity. Are these powers consistent with the preamble of Bill C-59, which claims to respect the Canadian Charter of Rights and Freedoms, the rule of law, as well as accountability and transparency, while championing national security? Amendments to the Act do advance safeguards, but the nature of these safeguards raise concerns. The bill includes provisions calling for the service to delete information in data sets regarding the physical or mental health of an individual or information subject to solicitor-client privilege and material and material in foreign datasets regarding Canadian citizens. This suggests some datasets will encapsulate information that should be accorded the highest degree of privacy. The question is, why would the Minister and Intelligence Commissioner approve a dataset that could potentially reveal this type of information about someone who has done nothing wrong? Further, the amendment should expressly state that accidental collection of such data will result in its total destruction, which clarifies the desired outcome more precisely than using the term delete. The Supreme Court of Canada has emphasized the protection of privacy is a prerequisite to individual security, self-fulfillment, and autonomy, as well as the maintenance of a thriving democratic society. Though not constitutionally protected itself, the right to privacy is essential for the maximum expression of most rights found under the Charter, including expression, peaceful assembly, association, the right to vote, right to life, liberty and security, fair trial rights, including prevention of unreasonable search and seizure, protecting the presumption of innocence, and maintaining solicitor-client privilege as part of satisfying the right to a fair trial, particularly the provision against self-incrimination. Acknowledging the impact on constitutionally protected rights, any limitation of privacy rights should be justified under Section 1 of the Charter by applying the Oakes test. If the courts identify...
You're past your time, but if you can wind it up in the next 30 seconds.
Sure. What I'll focus on instead are my recommendations. They are as follows. Ensure any limitation of human rights conforms with Canada's national and international obligations. Any encroachment on human rights must be necessary, proportionate, reasonable, and justifiable in a free and democratic society. The government must ensure any collection of personal data is directly linked to protecting public safety and national security, rather than being tangentially connected to the duties and functions of CSIS or any other agency. Legislation should be introduced to protect the Canadian populace from third-party commodification of personal data through payment or subscription. The National Security Intelligence Review Agency should be provided with the authority to render binding decisions, and the role of the Intelligence Commissioner should be elevated from a part-time to full-time status to reflect the breadth of their portfolio. Though
Thank you, Ms.
I
Shirley.
need to say
Yes.
some final words, and then I'll wrap it up.
The problem is that you end up cutting into members' time, and then they get mad at me, which is not really a good thing. So I'm going to turn
My final point is very important.
Okay, you can help her with that final point, Ms. DeBruzen. I'll leave
Thank
that
you
as to
kindly.
between the two of you.
If you can briefly provide me with your final point, please.
I greatly appreciate that. Though I cannot in good faith support legislation permitting mass surveillance for reasons outlined above, if this option is advanced, the following is recommended. Clearly and comprehensively define dataset, publicly available data, and exploitation of data. Keep a record of every time a dataset is created, queried, exploited, and by whom. The precise purpose for doing so should be recorded to enhance accountability. Records of such use should be sent periodically to the Intelligence Commissioner for review.
What you can do is you can actually provide us with some written submissions as well, and then we will all get it and we'll all be able to review it. But unfortunately, I don't have very much time, and I had some
Other
specific
questions. Thank you very much.
No, I'm happy you were able to get that. So I've mentioned this before over the past hearings, but one of the big issues for people in my community, one of the things that's come up a lot is proper oversight and ensuring that there's proper oversight across our national security agencies. So I wanted to start with a point that Mr. Edelman, you had raised. You suggested that, in fact, NCIRA is overly broad, which is a different perspective than I've heard a lot of. So I was hoping I could dig in just to ask. It seemed to me that the idea of having a broad institution that breaks across the silos was exactly what we were trying to get to. Would that be solved by having a different definition for national security? You had mentioned national security as being part of the problem.
Well, the concern that we have is with the vagueness of the mandate is what is NCIRA's, how is NCIRA to measure their, in relation to their mandate, how are they measure how they're being effective, and how are they to deploy their resources? And so if you have an overly broad definition of intelligence and national security in general, it covers such a broad swath of things that where there's an actual requirement for oversight, the NSERA may find themselves overwhelmed with complaints about the Canada Border Services Agency, for example, or looking into intelligence activities of the Department of Fisheries and Oceans, or this.
Curate, just because at this point we have legislation in front of us. From your perspective, what would you like to see us do to dig into that problem?
In my proposal, or what I would suggest, is that there be one clear definition of national security and threats to national security. The definition in the CSIS Act has been used for a long time, and it's only with C-51 that we ended up with another definition that created a lack of clarity with the Information Sharing Act. If the Information Sharing Act is going to be that broad, there's no question that there does need to be oversight. And so it may be that the broader definition from the Information Sharing Act is the one that ought to be used with respect to with respect to NSERA. Our view is that that definition is overly broad and vague. So
look, the CSIS Act definition might be something that would help.
In terms of looking at the definitions that are there already, we have the definition in the CSIS Act. With NSERA, there may be some concerns as to whether the CSE's mandate is somewhat broader, and there are some aspects of what the CSE is doing that might be outside of that. There may be some thought that might need to go into exactly what it is that NSERA is overseeing and where the gaps are with the other oversight agencies. So in terms of what it ought to cover or what ought to be covered by other agencies, in our submission, most of what CBSA does, for example, should just be covered by another oversight agency.
And I like that you raised that point, because that's something that I've also seized upon. We do have now NSERA covering across all the agencies, but you pointed out, and I just wanted to confirm that you would need a separate entity as an independent review of CBSA specifically. That's
correct.
Perfect. We were lucky that we were able to have an information commissioner come by. We were able to, for the CSC, just on Tuesday, I believe. And when I spoke and asked him some questions, I had a couple questions, was wondering what you would think. Right now, there's an obligation in the commissioner's role in this new act to have written reasons when an authorization is turned down. But there isn't that same obligation when the commissioner says yes and approves an authorization. Do you think that it would be helpful to have written reasons for the approvals as well as the turn downs?
Yes.
Yeah. The other part is for emergency authorizations. Everyone seems to accept that emergency situations may come up and you don't want to go through the regular process. But what about having an after-the-fact review by the CSE commissioner?
I think that's clearly ought to be done and ought to be a part of the mandate, in particular given the expertise that the CSE commissioner or the information commissioner in this case would have.
Perfect. Thank you. Interesting thought that was raised in a Citizens Lab report that I was reviewing was about having a security cleared amicus curiae to be able to review in private. This isn't a public review. To actually look at these decisions that are made by the commissioner, the reviews that are made. What do you think about that? Have you looked at that?
I mean, in terms of the role of amicus and the role of special advocates, there is definite, we do have this in certain circumstances where the courts will bring in amicus or will bring in special advocates with respect to specific concerns that the courts have. As to whether or not there ought to be a specific role, I mean, the CBA, it's not something that we've considered with respect to this particular framework, but it's definitely something that ought to be open and has been opened in the past to the federal court in terms of bringing amicus in with respect to specific concerns. And if you look at the REX decision that underlies a lot of the concerns here, my recollection is that amicus had been brought in that particular case to provide some submissions.
Thank you, and I think that rounds up our time.
Well, thank you for that, Ms. DeBruzen, and thank you for allowing Ms. Shirley to use some of your time. Mr. Palouse, 7 minutes, please.
Je parle en français.
I'll be speaking in French. If you could please put on your headsets.
Mon temps commence.
Can you hold on with the clock there, please? Thank you very much for being with us here today.
Maintenant que j'essaie de comprendre, là,
There's something I'm trying to get a handle on here. The two biggest intelligence agency in the world, perhaps you'll agree with me on this.
les deux plus grandes agences, c'est... Hop, stop. Je peux rien, je peux faire ça.
Okay.
Ouais, c'est ça. Je recommence.
I'll start again, if I may.
1, 2, 3.
Looks like. Okay. Can you hear all right? I can. Okay, good. Okay, Mr.
Parfait, c'est
Fellows.
So, once again, for me, the two biggest intelligence organizations in the world are Facebook and Google. I'm sure you'll agree. And the majority of Canadians are on these social networks. And I know that when you sign up for Facebook, you have to approve a number of provisions, and everyone checks them, and we can be followed closely everywhere we go. And folks don't have any trouble with that. And employees at Google, at Facebook, in California and elsewhere in the world know everything about our lives, and no one is making any complaints about this. But when it comes to the officers in charge of our national security intelligence to ensure that we are protected, they have their hands tied when it comes to protecting Canadians, and they're constrained. So I'd like to understand from you why Facebook and Google are off the hook, whereas our major security and intelligence agencies are constrained in this fashion. Well, it would be my submission that there are two main differences between Google and Facebook and Canada's intelligence and security agency. First and foremost, they are private companies that are not the police, they're not law enforcement, they do not have the same powers that any government or state would have. Second, you say that everyone agrees to handing over their personal data to Facebook and Google, but that's not true. It's a choice, and I do agree with you that the majority, even the vast majority of Canadians, make the choice to opt in. But when it comes to CSIS, Canadians don't have any choice if they're in their database. And those Canadians who would choose not to be in their database are those very same people that you would want to be in CSIS's database. And it would be my submission that you should take a look at police states. I'm a refugee attorney, and when you look at China, North Korea, Iran, these are countries that suppress rights, they deny rights, and they manage information in a non-transparent, unwieldy way, which in fact takes away rights and freedoms from their citizens. And I'm not saying that that's what our state is doing here, but I'm saying that it's one kind of protection. So you're saying that well, of course we don't want Canada to be a police state or to be like Northern Korea or China that are repressive. But the goal here is to understand that the world has evolved, threats have evolved, Facebook and Google have now become propaganda tools for hate speech, not just on our home soil, but sometimes from elsewhere. Let me give you an example of a video on YouTube where there's a proposal to attack Canada or blow up a bomb, but doesn't make any specific request to any specific individual. They just throw it out there willy-nilly. What about the legislation? Well, I'd recommend that you read what the Supreme Court decision was in Hamilton. And under Hamilton, there are instructions relating to fraud committed with credit cards. He didn't counsel any specific individuals to do so. What he did is he sold their data on the internet for $30 a pop how to defraud banks. And there was check boxes as to yes or no, how to commit such a crime. And the provincial court found that he didn't counsel crimes, specific crimes. However, the Supreme Court turned around and said it is in fact indeed an indictable crime. And this is a crime in relation to any crime, not just a terrorism-related crime. And, we can get into the details of Hamilton's decision, but under the law, it's already entrenched that, there were amendments to C59 regarding the terminology, whether it would be tighter or looser in terms of the provisions. Well, I think cards being broader than Hamilton would be problematic. Are we able to talk about specific crimes, the nature of what crimes are, to allude to other matters? There's always freedom of expression. Let me come back to Ms. Shirley now. In C59, there was amendment to Clause 5 on the exchange of security information. CISA, you alluded to it. I'd like to get your take on the difference between the threshold of reasonableness or reasonable grounds and what is definitely needed. So is likely to and is necessary to. Could you make the distinction?
I would recommend that the Standing Committee look at the jurisprudence of the Supreme Court of Canada to determine what the threshold for reasonableness is, because it would surely remain consistent regardless of the crime. If we're talking about invading the privacy of an individual, normally a warrant is required in order to do that. Yes, there might be exceptional circumstances in certain cases, but the Charter of Rights and Freedoms is in place for a reason, to constitutionally protect those rights, and any infringement must be reasonable. And simply saying that the collection of data relates to the functions of CSIS doesn't meet that threshold. Perhaps clearly demonstrating that there is an actual threat to national security may cross that threshold.
Sorry. Monsieur Dubé, 7 minutes, s'il vous plaît.
Merci beaucoup.
Thank you very much. One of the questions that comes up often is regards to information accessible to the public, and in Part 3 and Part 5 particularly. And in Canadian law or in common law, do you have a definition of what that is, information that's publicly accessible? Well, in many places in common law and jurisprudence, there's delimitations as to what's publicly accessible. There's a principle, i.e. that courts are open. It's the open court principle in English. And there's a lot of questioning about what that exactly means. It doesn't mean per se that everything that goes before the court is available online. It means that one can go before the clerk and request copies of certain files. There's no definition per se that's available to the public, but that's an example of publicly accessible information that in the Access to Information Act, there's a lot that's said about making information publicly available and what should be made available under the Access to Information Act. Question. If you look at Part 3, Section or Clause 24, 11.24.1, where it talks about publicly accessible information. Under Part 3, it relates to CSE, whereas under Part 5, it relates to information collected by CSIS. Do you consider that publicly accessible information is in fact defined properly in this bill, or do we need to clarify this definition? Well, it would be my submission that when it comes to publicly accessible information, this is information well, I see how it's problematic to the extent that there are private databases to which we have access if we pay for them or subscribe to them, that Ms. Shirley alluded to earlier, regarding a payment or subscription basis for commodification of data, particularly abroad in the United States. There are huge databases that are publicly accessible when it comes to making background checks. You can just pay to get a background check and access to a very large database of information. You can also pay through Twitter and Facebook. Facebook and Twitter sell their data to the public, and any Joe Blow can buy that data. And Facebook and Google doesn't care who's the buyer at the end of the day. So that's perhaps something that needs to be looked at when it comes to data that isn't in the public realm to the extent that it's not published, but by another token. Well, it's also a question of the difference or the distinction to be made. Well, here we're talking about information, generally speaking, but the restrictions relate to personal information, and that's a big distinction to be made. Personal information isn't of a technical nature necessarily, but sometimes you can have data from Statistics Canada or Google, Facebook, that isn't personal data under the legislation, but this information, for example, you could envisage that it could be used for training an algorithm that may be used for a neural network, so that at some point in time you could determine what an individual's sexual orientation is or their religion. But the algorithm, once it's designed and made, doesn't contain any personal information. So if you can sell the information that's used to conceive these algorithms, is that the same thing as actually directly having access to personal information? And there's the rub. It's all well and good to want to modernize the legislation regarding databases and current technologies, but something that we've always tried to make sure of in criminal law, and that is to use language in a fashion that it's technologically neutral. So the onus is on you to write the legislation in a manner that it will be forward-looking, so that the legislation doesn't have to be rewritten every 10 years. And, what the ramifications when it comes to algorithms. I'm not an expert when it comes to that. I'm an expert when it comes to legislation. However, when it comes to technology, there's a lot of questioning that needs to happen regarding what databases actually mean and who is using our intelligence services. So it's not just a distinction of what's public and what's not public. One last minute. Go ahead. Shall I?
I'd like to express my concern about the use of algorithms and the impact that it can have on democracy. If we're talking about the collection of information that is en masse, what it means is the agency that has access to that information is able to reasonably predict how an individual may vote, and if they're undecided, they may determine what factors may push them to vote one way or another. And that sort of information can be gained from analyzing these types of algorithms. And that's why it's so important to safeguard the privacy of Canadian citizens and ensure the preservation of democracy in Canada.
Thank you, Mr. Dubé. Mr. Fragiscato, 7 minutes, please.
Thank you very much, Chair, and thank you to all of you for appearing today. You're an academic, Ms. Shirley and Mr. Edelman and Ms. Carter, you're lawyers, but you are focusing on security issues, so I think it is important to ask you about the nature of the threat environment that Canada faces today. We've heard from a number of witnesses who have testified to the fact that, or what I believe to be a fact, that it's a multifaceted threat environment, and that as we try to create and craft legislation to confront that threat environment, we should not only be focused on one manifestation of terror, for example, Islamic radicalism, if you want to call it that, or Daesh in particular, and groups like it, that we ought to take a wider view and particularly look at the nature of hacking and the cyber element that terror is increasingly taking on. What is your view on this? Where should a responsible government be focused on from a threat perspective, from a security perspective?
From a threat and security perspective, I think it depends on the departments that you're talking about and the types of threats that you're... is the threat in North Korea, for example, of concern? Those are things that are obviously of concern to Canadians in terms of proliferation of nuclear weapons and things like that. That's within the ambit generally of the CSE and in collaboration with other agencies that we have these international types of threats that are dealt with, and that's where we have different agencies that deal with different aspects of the threat environment. The CBA is always and recognizes the need for balance in the sense that there are concerns around security and there are concerns around having an infrastructure that that people can be confident in, and that Canadians feel that they can trust. And so when we talk, whether we're talking about the threats of domestic, and in particular with respect to domestic threats, it's important that the agencies have the trust of the communities they're working with, whether those are and whether they're Canadian or non-Canadian communities.
I don't mean to interrupt you,
Sorry.
Mr. Edelman, but so you're of the view that ultimately, at the end of the day, I mean, you mentioned North Korea, for example. So, it's a multifaceted threat environment that we face. Ms. Shirley?
In short, I would say that if we're talking about the threat of terrorism, you are more likely to slip and die in the shower than you are to be the victim of a terror attack in Canada. And it so then follows... Does that mean that we need to regulate showers and ensure that there's surveillance in showers? We certainly do need to ensure that there is a balance. The Charter protects life, liberty, and security, not life, liberty, or security.
Thank you very much. In September, the government issued new regulations to Canadian security agencies to the effect that intelligence that may have been obtained through mistreatment or torture should not be used. There is an exception preventing the loss of life or significant personal injury, but prior to this directive, it was the case that such information could be used to secure property, for instance. Now, these are regulations. Would you advise that the government consider taking those regulations and implementing them in legislation? Because, as you well know, legislation is much more difficult to change.
Yes.
Okay. Then
I'll just leave it at that. Yes.
Okay, fair enough. I'll, unless Ms. Shirley, you had something, I'll go with a lawyer on that. But
I just like to express my view that I don't think that information obtained via torture should ever be used because it's not reliable, and there are a number of other factors that I don't have time to get into.
Okay. I would push you on that because I do think that when it comes to preventing the loss of life or significant personal injury,
if it's not reliable, it won't have that effect.
We're going to debate that all day. Okay. I wanted to ask Mr. Edelman, in the time that I have left here, you talked in your opening remarks about your concern about legal advice, solicitor-client privilege, and the National Security and Intelligence Review Agency. You had a concern on that. So, yes, NCIRA does have the power to compel information from any agency it investigates, including legal advice. But some commentators have made the observation that this is not unjustified, because if that legal advice to the government, let's say on a security matter, happens to be wrong, that the fact that it could open the door to an infringement of rights, then it would be good to review that so we can learn from it. It would serve as a safeguard. What do you think about that?
Well, there's two concerns around the issue with respect to privilege. One is with respect to the government documenting and seeking legal advice. And so the first step is the government going to seek legal advice? And should the government get, usually when we give legal advice, and when I give legal advice to a client, my legal advice is not this isn't, this is the way it is, this is the way it isn't. What legal advice often looks like is, here's where you're at no risk whatsoever. And then there's a spectrum as you start to get closer to the line. And how much do you want to push coming close to the line is a decision that's made by the person, and often a discussion and a dialogue that happens between counsel and the person or the individual getting advice. And I'm not saying that this helps people to push the line. It's that what will happen if these discussions are going to be disclosed is that instead of getting advice with respect to where the line is, what will happen is that either that advice will not be sought at all, or it will not be documented. And that undermines the whole purpose of the minister or whoever the person is making a decision, doing it in an informed way. And so if the person is going to cross the line, that should be done in an informed, with access to full, frank legal advice. And in terms of having the protection of the privilege, it allows for those frank discussions to happen. If that privilege is going to be breached or is going to be reviewed by this agency or other agencies in the future, and that privilege becomes meaningless, then that process of being able to get that advice is no longer going to function. And I would submit that it's just as important for private actors to be able to know the law and find out the law and get a sense of what the law is. And the privilege belongs to the government, not to the lawyer. And so if the government decides that, look, we did this thing, our lawyers told us to do it, well, you can disclose that. It's not the lawyer's privilege. So when the CBA when we come forward, we're not trying to protect a privilege that belongs to us as lawyers. My clients can disclose my advice whenever they want. It's a privilege that belongs to the client, because the client has a right to speak to me in a frank and fulsome manner, tell me everything that they want to know about, and I can explain the law to them so they can make decisions.
Thank you.
Sorry,
Thank you,
that was a
Mr.
lengthy...
Francis, guys. Yes, we're having a Law 101 there for our
I apologize
solicitor. Yeah. Mr. Motz, for the last 3 or 4 minutes, please.
Is it 3 or 4?
Well, depends on how
Yes,
quickly you speak.
Well, thank you. A couple of questions. I would hope, Ms. Shirley, that you're not asking the Liberals to regulate showers.
I'm certainly not. That was a joke.
If you do, they just might consider it, right? So let's not go down there. I guess, yeah, don't do. Sorry, I couldn't help myself. Just, I guess, Mr. Edelman, I want to ask you questions, given your background. If you were to add something to C-59 that you think is absolutely critical for public safety, balancing the need for rights and privacy, what would you suggest that be?
Look, we have 30 recommendations in our written submissions. I mean, in terms of public safety itself.
Or less.
Sorry?
And 30 seconds or less.
30 seconds or less. I'll be very quick. In terms of the public safety mandate or aspect, I would say that the mandate of the NSERA is something that ought to be clarified. And in terms of some of the things I talked about at the beginning, the lack of clarity with respect to the definitions around national security actually do undermine the overall functioning of the overall infrastructure. And so in terms of the broad picture, the one thing that I would fix is make sure that you get the forest right. I have a whole bunch of recommendations around trees. That would be my recommendation around the forest.
Okay, thank you very much. And for my last comment, I can't help but suggest, Ms. Shirley, that your analogy to the shower, your showers never threaten to blow you up because you live in a democracy. So the whole issue of national security, the whole issue of terrorism and the risk that we have in this country, is serious, and that's obviously something that we, as a committee, are taking very seriously. So I appreciate the comments all of you had to make. And one last, Mr. Francostatos asked a question about your assessment, all of your assessment as regards to the risk of terrorism globally, basically. So I just, yes or no, have you had any training or operational experience on risk assessments of terrorism?
Other than in my work in national security cases, no, I do not have training in risk assessment. I recognize the risk of that there's a multifaceted risk from a number of different places.
Okay.
Thank you. Thank you, Mons. And on behalf of the committee, I want to thank each of you for your efforts of coming here and sharing your insights with us as we study this very, very important bill. With that, I'm going to adjourn, but remind those who are on the subcommittee that we are meeting immediately after, and it is in camera, so I'd ask for cooperation in emptying the room for those who are not entitled to be here. So with that, meeting's adjourned.
Thank you.